this. Awesome. So today's call, we're mainly covering, the FCRA 605B FTC affidavit process. And I'm also going to touch base on some updates on the Experian direct portal upload process. A couple of new findings that'll help you guys navigate and give you some troubleshooting steps as time goes on, because everyone runs into different situations, but some may not have run into it yet. And this will be a great opportunity for you guys to get ahead of it. But to start, we're going to get right into this. I've had some questions over the last week or so, really just related to the FCRA 605B dispute method using an FTC affidavit, what that means. Is it ethical? Are we doing things right? So what I want to do is focus on educating you guys on the basic fundamentals, the basic functions of this method, what they all mean, what is an identity theft affidavit, what can it be used for? I think that's where, some of the questions are coming around, because I think the assumption is that it's limited to being used for identity theft, while it's also used for fraud, right? Is identity theft fraud, right? Affidavit. So it's for both, and it could be used for specific situations. And I'm going to dive real deep and give you guys all of the evidence that you guys need in order to truly understand this, right? Because you don't want to be applying a process you're not fully confident in, because I think that can happen at times where people are going through disputes. They're online and they're listening to people talking about things. And, when you're on Instagram and Facebook, and people are telling you what to do and what not to do, you know, I always encourage people to just do their own research. Like, that's cool. Like, that's, very value added. But if they're not actually providing the sources, which I always do from the very beginning, right? If you guys are navigating through each and every module and you're not skipping the details in the videos, you're going to see why I teach the way I teach. I cover everything from the very beginning. I don't just go straight into the method. I start with the actual background. Like, what is the Fair Trade Commission? What is the FCRA 605B, right? And I covered all of the beginning information, and I cover all of the basics, because people love to rush into things and they love to go into methods, and they're like, oh, well, this is working. Let's do it, without really fully understanding. So my goal is to really just create another video to dive into this, so that I can give more clarity, but also encourage people to really slow down when you're going through all the material in the university, because I cover everything, and I would not be sharing a method that I'm not confident in and I've actually applied and done my due diligence on, right? So all of this stuff I've not only applied, but I studied this stuff. All right. I studied it. I looked at it from different angles, and I completely comprehend it. And I've also been in the field dealing with the bureaus enough over the phone via letters to know, why we can and can't use this, and what reasons we can use this for. So to get right into it, we're going to start with really what FCRA 605B is, right? It's so under the FCRA 605B, a consumer reporting agency must block any information identified by a consumer as resulting from identity theft within 4 days if the consumer provides proof of identity, a copy of identity theft report, identification of the fraudulent information, and a statement that does not relate to the consumer's transactions. So this is the general overview of the minimal requirements you need to submit it. Because once you submitted this, then now the agencies are obligated to perform, right? Because that's what this law states, is as long as you're providing your ID, you provide your identity theft report, which is the FTC affidavit, and you provide proof of identity, right? AKA your social ID, proof of address, right? Those are all proofs of identity. Then they have to fulfill this, right? So the agency must notify the sources of information that it may be related to identity theft, and that a block has been requested. So the agency can decline or rescind a block if it finds that the request was made in error based on false information, and the consumer must be notified if it happens. However, this section does not apply to resellers that do not furnish or resell consumer reports at time of the request. So we're going to dive deep into really what can they decline and rescind, and what do they need to do when they decline and rescind, and then also what are resellers, right? What does that mean, right? I'm going to dive into that as well, and I'm going to share with you who those are, okay? But to cover the actual general basis of the full law, right? If you go right to Cornell law, this is where I got this from, right? In Cornell law, FCRA 605B, also known as this law, 15 USC 1681 C2, right? So Section A for a block, except as otherwise provided in this section, a consumer reporting agency shall block the reporting of any information on a file of a consumer that the consumer identifies as the following is resulted from alleged identity theft. Right? I want you to put two and two together. I need you to pay attention to what a lot of these words mean. Right? This is coming from the law, and this is why when we're listening to people on the internet, it's like they're not really truly diving deep into this information, right? How many of us have received letters from credit debt collectors about alleged debt or this alleged debt, right? The verbiage in itself is important for the simple fact that when you start breaking down all this legalese, because that's what it is. A lot of the words in these laws mean more than one thing, right? So let's just slow down and confirm what is alleged, like, right? What is alleged, right? So in law, alleged describes a claim or accusation that has been made but not yet proven true. So we're going to come back to this. It's not yet proven true. It's used to describe someone who is accused of wrongdoing, like a criminal, before the court has reached a final judgment. The term alleged is often used in news reports and legal documents to indicate that the statement is made but hasn't been verified. Okay? Pay attention to these words, guys. I'm diving real deep. I'm slowing down to show you the fundamentals of what these laws mean and what they're saying, right? So now that we identified that this is all based off of alleged identity theft, right? And it requires some type of proof, right? Some type of burden of proof. We'll discuss later on who that proof is falls on, right? Who's responsible of proving this? That's where a lot of people get confused, but we're going to dive into that. So appropriate proof of identity of the consumer, right? Like I said, your ID, social, proof of address, etc., right? So they can verify it's you. And a statement by a consumer that the information is not information related to any transaction by the consumer. Notification. A consumer reporting agency shall promptly notify the furnisher of information identified by the consumer under subsection A of this section, so that the information may be a result of identity theft and that the identity theft report has been filed. A block has been requested under this section and of the effective dates of the block. So what it means here is they communicate with the furnisher. If you send this in, they're communicating with the furnisher. Now, what you also have to remember is the credit bureaus have a responsibility under the FCRA, just as so do the furnishers. They both have to follow the same laws, right? Although the consumer reporting agency is the one reporting it, right? Because we're not pulling up a Amex credit report. We're pulling up a Equifax, TransUnion, and Experian credit report. This is why I teach you guys to dispute with the credit bureaus, right? Versus disputing with the creditors with this process, is because we're forcing their hand, right? If the credit bureaus did everything that they are required to do by law, I need you guys to pay attention to this. If they're doing everything they are required to do by law, then they shouldn't have any issues proving it, right? because the burden of proof is on the consumer reporting agencies, right? When it comes to these alleged accounts, right? They have to prove that they did everything correctly when reporting them. This is where we're exposing it. And this is what you guys have to understand about the FTC affidavit and the dispute method, because it's a statement of truth. When you're submitting an affidavit, you're claiming that you, in truth, are reporting that this piece of information has been reported based off of fraud or identity theft. It's one or the other. And I'm going to explain to you guys later on what it means, right? Because it could be one or the other. It is a FTC fraud affidavit. While the report is circled around identity theft, people aren't paying attention to what the laws are saying, right? It's fraud or identity theft. So the credit reporting agencies have the authority to decline or rescind. In general, a consumer reporting agency may decline or block, right? Or may rescind any information related to the consumer under this section. So if a consumer reporting agency reasonably determines, so that's 3 reasons why they can block this information and refuse it, right? They're going to send you a notification in some way, shape, or form that has been refused, right? It's been rejected, but they have to give you a valid reason. So the information was blocked in error, or the block was requested by a consumer in error. This is one I see very commonly with Equifax, TransUnion, and Experian, especially when you guys are diving deep into the dispute and you're reading the letter they sent you. You'll either receive it via mail. More commonly, you'll get it by mail with Equifax, but you'll also receive emails from Experian, and depending on whether you have a TransUnion portal set up, you'll get a TransUnion portal set up notification via email telling you that it's been blocked, that's been rejected, right? For various reasons, but they're never really specific with what the reasons are. And usually this happens within that 3-4 day window. So the information was blocked, or a block was requested by a consumer on the basis of material misrepresentation of fact by the consumer relevant to the request or the block. The consumer obtained possession of the goods, services, or money as a result of the block transaction or transactions. So there's a couple things that need to happen here. You can rescind it, right? You can actually rescind a block by letting them know, hey, I've claimed back what was mine, whether it was good, service, etc., and everything is square, right? Because if legitimately is happening where you have a situation with, fraudulent transactions that are affecting your credit score, you can have it rescinded if, you work with the bank and it's fixed, right? Whether it be late payment, etc., whatever that may be, you can actually rescind it so you can reverse it. Now, I want you guys to pay attention because it's telling you how much power you have. You have the power to rescind this process just as much as you have the power to apply it. Why? Because it's your consumer report. And they're doing a job on behalf of you by reporting it. They're a consumer reporting agency. It's their job to act in your best interest. So when we're submitting these disputes, we're placing the burden of proof on them. We're giving them an opportunity to show us that everything's legit. Because if everything is legit, then we'd be receiving all the paperwork and accordingly, right? Whether that be wet signature contracts and agreements, original documents, official statements, proof of communication, right? As I've explained to you guys before, how our investigations need to happen, they're like almost a crime. It's almost like a crime scene, right? These credit bureaus are supposed to be calling these creditors and requesting the specific information. They're supposed to be following through with all of the issues that are happening. And they're supposed to be obtaining documentation from the furnishers. This documentation is part of the investigation. So if they don't have any documentation and they can't prove it with the documentation, then they didn't investigate to begin with. And what I've always been telling you guys is these credit bureaus are not doing any investigations, nor will they do any investigations. There are way too many disputes being sent out regularly. They don't have enough manpower to do individual investigations. They rely on systems to verify the information. So notification to a consumer, if a block of information is declined, they're supposed to send a notification, right? Now, this is what I was explaining to you guys. You're going to get it either via the portal or via mail. And it usually arrives within 5 business days of submission of it, right? And they must give you this disclosure. Now, there's many cases where I've actually proven to you guys that they send the notification, but they still process the block, meaning that the original notification wasn't legit, right? Because how can you deny me of the block, but then still move forward with it? There's something off there. Not just another proof that I'm going to show you later on, right? I have it in this campus. It was on a TransUnion account where they sent out a letter. Matter of fact, I have it in here. Right, I have it in here. All right, here it is. Perfect. So TransUnion sent this, right? The fraud block was declined. All right, so we received the fraud block request you recently sent to TransUnion. Takes causes of identity theft very serious, investigates all such allegations thoroughly. Right? It's all fluff.
Yeah.
Right? Now, as you can see this, it's saying that on the 25th, right? I want you to pay attention to these accounts. You got Upstart, Toyota Motor, Cap One, DCU, LVN Funding. Again, I'm almost going to show you guys the proof. Now, pay attention to these dates. What accounts are these? Capital One, DCU, LVN Funding. What are the dates here? 10/1. This was submitted on 9/25. So if you're thoroughly investigating and if you truly declined it, well, why were they removed? Right? I'm telling you, everything is systemated. It's system automated, right? It just machines. They're just pumping these emails out. There's just notifications. They assess your documents. And if you don't craft your letters with the right laws and you don't know how to dispute, this is why I teach you guys how to actually understand the FCRAs, and I break down what laws we're using and what reason we're using them for. Right? When we're disputing late payments, it's not the same way as disputing collections. They're all different. We use very different laws because you have to be able to enforce it and you have to understand how they work. Right? So if they're following FCRA 605B, right? How is it that they're sending me notification or sending notification of these accounts being blocked, but deleting them later on, right? It's not consistent, right? And that's just one example.
Oh,
That's really covering specifically the notification piece and, right, the notification piece and how they need to communicate with you whenever they decide not to move forward with it, okay? And then this section really breaks down resellers. So we're going to get right into resellers right after this, but exceptions are for resellers. So no reseller file. This section shall not apply to a consumer reporting agency if the consumer reporting agency is a reseller. Is not at the time of the request of the consumer under subsection A of this section, otherwise furnishing or selling a consumer report concerning the information identified by the consumer. It informs the consumer by any means that the consumer may report the identity theft to the Bureau to obtain consumer information regarding identity theft. So examples of resellers are secondary bureaus, guys, right? Secondary bureaus are the 𝐶oreLogics, LexisNexis, Innovis, SageTree, MicroBilt, DataX, Clarity Services. These resellers are the only exception to this law. So you can't really leverage the FTC affidavit when it comes to disputing with them because they are an exception, right? They are an exception. There's a different set of laws you have to follow when disputing inaccurate information with these guys. It's very different, right? So, and this is really why it's important to understand this stuff, right? Who's a reseller? What are we talking about? Notifications, right? How long should it take for them to process a block, right? This is all the stuff we're diving into. So now we're going to shift into the real meat and potatoes, right? We're getting into the whys. We're explaining to you, I'm going to explain to you why we're using this and why we can use it and why it's working to our advantage and why the credit bureaus really have no leg to stand on with this. So the Fair Credit Reporting Act governs how information is reported to and by consumer reporting agencies. Specific sections of the FCRA that enforce the accurate reporting of information include the following key provisions, right? So 15 USC 1681 S2 is furnisher's responsibility to only report accurate information. Remember that. Nothing can be inaccurate. Now, I guarantee you every single person on this call could look on their credit report, and even the positive accounts have inaccurate information. I can guarantee it.
Always.
Right? Only report accurate information. They must correct or delete false or unverifiable data. Investigate disputes forwarded by CRAs, right? This is also the furnisher, guys. This is the furnisher. CRAs must reinvestigate disputed items within 30 days, delete unverifiable or inaccurate information. So these are their roles. So I'm teaching you guys what are the roles between the two of them based on these laws, right? Because the information ends up getting forwarded to the furnishers. It does. But what you guys are failing to understand is that these furnishers are holding on to so many files. They're not being thorough when it comes to furnishing information. So they're furnishing inaccurate information. Now, when it gets to the second level, which is the CRA, it's even worse because now the CRAs have inaccurate information that they have to go back to the furnishers that furnish inaccurate information for. So from bottom to top, it's already a disaster. So when you're disputing with the credit reporting agencies, it is much easier to receive a response and a result from because they're not the original source, right? It's easy for the furnisher to just claim it's verified, right? They're just going to flip a switch, say it's verified, even if it's not verified and even if it's inaccurate, right? This is why I'm going to be teaching you guys how to create litigation letters, right? Because when it comes to dealing with the furnishers, right, you can skip the CRAs. With the furnishers, that's when you start hitting them with, and you understand the sequence that I teach you guys here on how to properly dispute. You don't have to go many rounds to now start threatening the furnishers with invoices, right? You can start actually threatening them for willful and for willful non-compliance, right, and negligence, because those are all violations, and that's how they're held accountable, right, for actual damages, etc.
I'm tired right now. Okay. I'll probably get some energy
A little bit later.
but I don't want to take that away from me.
Sorry. So that being said, you can start escalating it. But the way I teach you guys is go straight for the CRAs because CRAs already have skewed information. CRAs are already a mess. They're already a disaster. They have inaccurate information that they're not truly holding. The furnishers are holding. They have to go back to the furnisher to verify, which they can't because the furnisher doesn't have it to begin with. (15 U.S.C. 1681 C2), blocking information resulting from identity theft, right? This allows a consumer to request a block of any information on their file that has resulted from an identity theft, including fraudulent accounts. Now, I want you to think about this, guys. When you think about the word fraud, right, you have to think about it in a sense of its own definition, right? Fraud is technically when somebody is performing an act that's benefiting them without your consent, right? Or without your knowledge. Whether that's taking your credit card out of your bag and using it to buy things without you knowing, right? Those are fraudulent transactions because you're not aware of them. Consumer reporting agencies and furnishers have specific laws they're also required to follow in relation to them having written authorization from you, which they have to also prove to furnish information. But when we're disputing, we're requesting for that information with the CRAs, right? Because we know that the CRAs don't have that. And for them to get it from the furnishers, they only have 30 days. Furnishers don't have all that information, guys. There's a very intentional way we're disputing, and I teach you guys to do this very methodical because there's thought behind this. I want you guys to also remember that I learned a lot of these tactics too from a consumer law attorney. He's beat these bureaus in court, right? So the way he teaches is very simple, and he just breaks down the basics. Where does it all come from? How does it stem? How can you challenge them? Because it's not even just a matter of citing these laws. It's just a matter of knowing how to use it against them. That's the real play. You got to force their hand because you're not making claims. After you've submitted a dispute claiming an inaccuracy, from there, you're now challenging how they investigate. There is no more disputes. The dispute's already done. Now the ball's on their court. They can't come back and just say it's verified. They have to actually show you. Penalties for violations. So violations of the FCRA can lead to civil liability, right? Including actual damages, punitive damages, if willful, right? Willful non-compliance, that's what I was sharing with you earlier, and then attorney fees, right? They'll cover all of it, whether it's through arbitration or you're simply just taking them to civil, to court, right? You take them to a district court, they're gonna have to cover all of that when they lose, on top of the damages, right? And then when we talk about actual damages, that's like when you're really dealing with it, right? Because when it's impacting your general mode of living, right, it was causing you stress or harm in some way, shape, or form, that's damages, right? Punitive is under the willful, where willful non-compliance, you can basically fine them anywhere no less than 100 and no more than 1,000 per violation. This one can be pretty limited when you're dealing with the actual disputes. So if I'm disputing 4 inquiries, right, that's a potential $4,000 because it's per violation. Or if it's 4 accounts. So you're pretty much maxed out at that 4K. But if you're dealing with the actual damages, and you're able to prove things, right? You're able to prove that you went through actual damages, there's no limit to it. Especially when it comes to things like mental health, stress, anxiety, right? All those things, when you can prove that you went through that, you can hit them for as much as you want because there's no actual gauge for that. They can gauge how many negative inquiries there were on there or unauthorized inquiries. They can gauge how many inaccurate accounts there were on there, but they can't gauge the actual damages. So does the FTC affidavit only apply to identity theft? Not exactly, right? While this 605B is framed around identity theft, right, it includes any information that is result of identity theft. So what is identity theft, guys? I want you guys to think twice about this. Identity theft is something as simple as me taking your information in some way, shape, or form without your knowledge to use it for my gain and my benefit. So how do the credit reporting agencies and the furnishers benefit from this information? They get paid to report this information. It's in their business model. Their business only operates from the reporting of information. They're a consumer reporting agency. So who's really benefiting when it comes to reporting? Is it you or them? It's them. So if they're benefiting from reporting information that is not accurate, right? Because what does this law say? Right? They have to report accurate information. Accurate, only accurate information. So if it's not accurate and they're not deleting it, what's happening? Your credit report is impacted and you're trying to take control of it, but the credit reporting agencies that are supposed to be following the laws aren't actually doing anything about it. So what option do you have? You put the ball on their court. You challenge the accounts using an affidavit. Why is the affidavit so powerful? Because it's under penalty and perjury. Because once the ball is on their court, who has to turn around and now prove that it isn't fraud? Guys, you've already submitted an affidavit. There's nothing else to prove. They're the ones to prove it. Right? This encompasses many types of fraudulent accounts, unauthorized inquiries, collections. Fraudulent items fall under this category if they were a result of identity theft or unauthorized activity, guys. I need you to remember this. Fraud is when something is happening to you for the benefit of someone else without your knowledge or authorization. Right? And I'm going to dive even deeper. A lot of you guys don't even understand that a collection alone shouldn't even be on a credit report. A charge-off shouldn't even be on a credit report. Why? Because the IRS says so. The IRS states that income is not reported on a consumer report, and that if an item is in collection, it is reported as income for that year. Since when does income report on a consumer's report? Right? Pull up a 1099-C to show you guys. Because I like to show you guys stuff. It says it right in the instructions. From 1099-C must be filed regardless of whether the debtor is required to report the debt income. Right? Because the Form 1099-C must be filed regardless of whether the debtor is required to report the debt as income. The 1099-C is considered income. Where I'm going to chat GBT it too. I'm gonna ask for a short answer. More precise. Collections are considered income only if you're in a cash basis and you're receiving payments for goods and services, you're recovering from previously deducted debt, and you're in business of collecting the debt for profit. Otherwise, they're generally not considered income. So collecting a loan payment you made or funds held on behalf of others. So when filing a 1099-C, right, collections are considered income only if they're on a cash basis and receive payments for a payment for good/services. You're recovering a previously deducted amount of bad debt, right? Because what are the companies actually doing? What is a collection, guys?
Recovering.
It's a recovery. I mean, the companies are trying to recover a debt. So it's in collections. That's why it's collections. Right? If it's funds held, right? If they're collecting on a loan payment, repayment you made, or funds held on behalf of others, the only exception. But the key here is you're looking at the recovery of a debt. And when they're collecting a debt and they're reporting on your consumer report, it's considered income. And that's also another reason why it shouldn't be reporting on your consumer report. Right? So FTC Identity Theft Report together with the police report or substitute statement under penalty of perjury satisfies the requirements under the FCRA 605B. So when you use this report, right, you're stating that in truth that these accounts, right, are reporting without authorization, because when you challenge them and you're requesting that they're accurately updated and they're not, they're all being reported without your consent. Because even 15 USC 1666B requires permissible purpose. Permissible purpose is basically, it states that under the consumer disclosure, that a consumer reporting agency must have written authorization from the consumer prior to furnishing information on the consumer report and handwritten signature. Right? Under this disclosure, permissible purpose. Under the right disclosure to consumer, right? A clear and conspicuous disclosure has been made in writing to a consumer at any time before the report is procured or caused to be procured, and the document exists solely of the disclosure that the consumer report may be obtained for employment purposes. Now, the consumer has authorized in writing which authorization may be made on the document referred to in the clause in the procurement reported by person. Right? As we look down to the conditions, it states here that, where is it? Signature. Wet signature. All right, so a description in writing. So where is it? I'm trying to find it for you guys to show you because I only like to show you guys. Here it is, right? A consumer has authorized in writing, guys. which is authorization being made in the document referred in the clause of procurement of the report by the person. A clear and conspicuous disclosure has been made in writing to the consumer that at any time before the report is procured or caused to be procured. So anytime something is being furnished, anytime something's being reported, you are supposed to be notified because they're accessing your credit report. So when you're challenging this information, whether you're challenging with the credit bureaus, this is what you're requesting, right? When you're using the law of permissible purpose, this is a really good law specifically for inquiries, right? Because they have to actually pull your report to report an inquiry. But it also falls in line with all the other items because in order for even an inquiry to be reported, someone had to access your file. So when you're requesting what the permissible purpose is, this is what you're requesting. You're requesting the clear and conspicuous disclosure and the authorized handwritten authorization. All these laws are supporting it, right? And as much as I would love to dive deep into the info and all of this, it's a lot of laws. As you can see, I've had to read a lot to actually know where a lot of this information is. But you have to pay close attention, right? You have to pay close attention to what all this stuff means. So when we dive back into the identity theft report, once it's been submitted, you guys have to remember that the burden of proof falls under the CRA. So after a valid identity theft or FTC report is submitted to the CRAs of the furnishers, the burden of proof shifts to the CRA and the furnisher, right? They must block and dispute the disputed items within 4 days, not reinsert the item unless the furnisher certifies that it is accurate and is not a result of identity theft, and notify the consumer of reinsertion if reinsertion happens. Maintain reasonable procedures to avoid re-reporting blocked info. Right? And what you guys are failing to also realize is when they're re-reporting information and the information is not accurate, right, as it should be, they're in violation. So why do we use the affidavit to enforce it? Because the affidavit puts them in a position where they have to actually prove their case. They have to be able to prove that everything's valid, right? That everything is authorized, then no fraud was committed. But when you pay close attention to how all this stuff is working, you'll realize that all of it is fraud to begin with.
And it has to be certified.
All of it.
Certified by accountant. It's a financial statement.
All of it. And there's no actual burden of proof, right? There's no burden of proof. Anytime you guys are submitting these, and I share with you guys, like I just shared an example earlier that they rescinded, I mean, they failed to block, right? They rejected a block, but later proceeded to remove the items. That's not actual procedure that they're following. What they should have done is they should have held strong with the rejection and provided proof. As I tell you guys, a burden of proof always shifts on the CRAs and the furnishers. Everyone thinks that using the affidavit falls on them. No, once you place the affidavit on their lap, they have to prove otherwise, that it's not. Now, what I will share is there's a lot of people I've seen on the internet using some method called it's called what, human trafficking. They use the human trafficking to dispute items off their credit. That's ludicrous, right? In this particular case, I'm showing you guys the definitions. What is fraud? What is identity theft? And how it all intertwines. People just don't understand the definitions.
So how did they use human trafficking in this type of credit reporting? How does it connect? I never understood.
Well, what happens is what they're doing is they're submitting, and I've never even thought to even look into it because it just, to me, it sounds crazy, right? Because in order for you to be human trafficked, you got to be human trafficked. But for a company to commit fraud, they simply just have to do something that was unauthorized by you. That's fraud. Like the definition
Right.
is straightforward.
Yeah.
It's not even like you have to be the wisest person to understand that if something's done without your authorization, right, for the benefit of someone else, it's fraud.
Yeah.
That's it.
That-
Like it's and you're
It's
using
just enough that they didn't give you disclosure. That's enough.
exactly. So you're using a statement of truth to force them to prove that it isn't fraud. Now, and I explain this to people is, and the only way for them to be able to prove it is by them unraveling the fraud they are committing, because they have to now share the methods in which they did take to verify, which they're not, right? They're going to expose all the violations because they have to violate FCRA laws in order to get that information on your file, right? Hence, they violated 15 USC 1681 S2, right? Inaccurate information. They have to literally uncover all the violations to prove that it isn't fraud or identity theft. The burden of proof is on them. So it's not for us to worry. Our job is to simply follow what the law says. And when you understand the definitions, you're following what it says. I mean, even something as simple as using the FTC affidavit for inquiries that are on your report that you didn't get credit for. You didn't receive any credit if you have 15 inquiries from a dealership. Like he just ripped you for 15 inquiries for one pull. Did you authorize all 15 or did you go there with one? Did you ask him to pull your credit once? Right? If you received credit for that item, you don't want to be claiming that there wasn't authorized because it's on your credit report as the account, right? If you got a Chase credit card and there's an inquiry for Chase on that date that it was approved for, you're not disputing that. And that's the last thing I would tell you guys to dispute. What you're disputing is unauthorized, right? You didn't get anything in return for it. The same thing when they're reporting collections on your file, who authorized for the collection to be reported? Where is the handwritten disclosure, right? Authorizations, when it comes to inquiries, you can leverage permissible purpose, right? You can leverage permissible purpose, or you can leverage the FTC affidavit for unauthorized inquiries as a fraudulent inquiry. The affidavit is used for either or, for identity theft or fraud, which are very much in the same realm. But without understanding what the stuff means, then you're just going to have your doubts. You're not going to understand how it works. I just broke down a case for you guys in the campus of a gentleman who basically won a settlement with the credit bureaus using this exact same laws because they can't prove anything. The FTC affidavit is one of the most powerful things you can use. And the reason I share it with you guys is because the old method of disputing is a complete sham. It's a waste of your time. By the time you finish cleaning up your credit, it'll be 2027, right? And you'll still probably not even have everything off your file because you're just going to keep getting back verified disputes. You know, everything that the bureaus are supposed to be doing isn't being done. So why are we not leveraging an affidavit, which the government created for us to use in these situations? It's pretty cut and dry, right? And if they fail to actually follow through with any of this, guys, right, you can hold them accountable for civil liability. Well, And all of this comes down to you understanding how this stuff works. Because you are the one in power. They have to do their job and show that they investigated, show that they have the proof, show that they had all rights to report it. Because it's their job. Their only job is to report. But I also want you to think about this, guys. How is it that I want you to also think about this? Theoretically, let's say, somebody stole my identity, right? And they opened up like 5 credit cards under my name. And I went and I reported to the bureaus. But then they send me some BS email like this. And I'm literally trying to tell them, yo, somebody opened these accounts on my file. But then they're sending me sham emails. So what do you do next? You take their word or you keep fighting? Burden of proof is on them. Because you can't sit here and tell me that it didn't happen. Because if you claim that it did, prove it. Because I've given you everything I'm required, right? Because what does this law say you're required to have? Right? Consumer reporting agency must block any information identified by a consumer as resulting from identity theft within 4 days if the consumer provides proof of identity, a copy of identity theft report, identification of the fraudulent information, and the statement that does not relate to the consumer's transactions. This is all you need to provide. What does the law say? What else does the law say you need to provide? It doesn't say the consumer also need to provide something else. That's it. That's all you need to provide. I didn't create any of these laws, right? These were all put in place for us. The FCRA was put in place for us. But if you don't understand how to use it, then we're going to be walked all over, right? There's a reason why I'm building a litigation case because I know I'm seeing the trend, guys. I've been disputing for a couple of years now, and it's changed so fast. Like regular disputes aren't a thing anymore. And the people who are using regular disputes,
Wasting
they're
their
just
time.
in for the long run. They're just in for the long run, and that's it. They're going to be disputing for the end of time.
Them playing their game. You gotta play your game.
You got to understand how to leverage these laws the way I teach you guys. And the reason I go back down to the basics is to give you guys the power to understand this stuff because the internet will dilute you. And I'm not getting this information from the internet. I'm getting it from the source. This is straight from the source. These are the laws. And I'm just simplifying it for you, breaking it down to help you guys understand what they're supposed to do and what they can't do. And what we're doing is legitimate because you're going to hear a lot of, man, you shouldn't be doing that. It's against the law. But where? Show me. I want you to pull up one case where a credit bureau sued a consumer for using an affidavit.
Never.
They can't because they're not doing their job to begin with. They have to expose their fraud to even go that far. They're setting themselves up first.
I don't think even a creditor ever sue.
No, never. Because it's all fraud. What you have to understand is at the end of the day, they're not actually reporting accurate information. Guys, even positive accounts, I need you guys to remember that. If it's all greens across the board and you're on time and you had it for 10 years and it's paid off and you got 5 more payments left on the account, but then the dates that were opened isn't accurate, that's inaccurate. It's a violation. End of story. We're not giving them any room to wiggle. That's your credit report. Either you take it serious or they're gonna play with it. Right? And I wanted to do this call because there were some questions, and it was really just clear things up for you guys, because you have to dive into the material I share with you, because I'm sharing it all with you, right? And this is why it's important. If you have questions, keep using the Q&A chat. I'm always answering. But the ticket is to slow down and read the information, because I'm never going to throw a process into you guys and be like, yeah, just go ahead and run it. And I don't know anything about it. I understand these processes in and out. I'm actively enforcing this stuff always. So the general basis of this is, does the FTC affidavit only apply to identity theft? No, it does not. It is framed around identity theft. And once you make an argument, guys, once you make a claim, the burden of proof is on the consumer reporting agencies and the furnishers. It's the same way I walk up to you and I go to court and I'm like, yeah, this person hit me. Okay. Well, is there any witnesses? Does somebody see it? Do you have a video of it? I've made a claim. Now the other person has to prove it. Or they made a claim and they have to prove it, that it didn't happen. The burden of proof is on them. The table's turned. It's shifted. Here's everything you need. This is the law. It's your turn. That's all we're doing here, guys. Because if any of that stuff that people are saying on the internet was true, why are the bureaus folding like cakes with this process? Right? It's not as effective as it used to be 6 months ago. I'll tell you that much. I think now what's happening is these bureaus are starting to become a little bit more negligent. That's why I tell you guys, you're going to end up having to litigate them in some cases. It's not always. You're always going to get remedy, right? Right? As Teddy said, Teddy, he dropped some game. He said, man, like, you apply the pressure and you over deliver, you're going to get the results. The process works. I mean, you're going from 6, 7 months of disputes to 2, 3 weeks. You know how much time you save yourself, and 2, how much headache and stress, and 3, you're not doing anything wrong because you're following what the law says. I've shared with you guys what it says here, what you have to produce, what they need. At what basis do you file an identity theft affidavit for? Because remember, affidavit is a statement of truth. People are only thinking of it as identity theft, because in a sense, it is identity theft. But it's also to report fraud, right? Fraud is a result of identity theft. People don't quite understand that. They think that someone has to truly, go and apply for those accounts. No, even just the reporting of that information without authorization is fraud, because there's nothing in it for you to benefit from. There's really not, right? And I've given you the general basis. When I shared the lawsuit with each and every one of you guys, this was the basis they used to win that case. And it wasn't that they won it, because there is no winning when it comes to this. They do settlements, right? They're going to pay you out because they can't win. You can't win. That'll expose everything, right? And they can't continue making their money. So what they're going to do is going to pay you out. This law was what was used as a general basis. The argument wasn't FCRA 605B. And if you guys go back and watch that video that I shared with you in the training section, right? I got that training video right here for you guys. You'll see exactly what I'm talking about. That they leveraged a fraud affidavit when they submitted their dispute, but yet the Bureau still failed to follow the proper procedures that they're responsible for and only report accurate information. You're always going to win when you're using the laws against them, guys. Like, all of this stuff isn't cookie cutter. It's right in front of us. But I shared that lawsuit because I actually learned from that. If I hadn't gone through that, for me personally, if I was to file some sort of a complaint in court and sue, etc., I would be using this law. Well, that's a completely different argument, right? Where all of this is related to this. This is the meat and potatoes of all you need to know about credit report. Right? It's the meat and potatoes. That's all you need to know is which law. And I call this the mission statement of credit reporting. It's the absolute mission statement. When you are going back to the FCRAs and you're reading through every single law, regulation, etc., right? This is the real meat and potatoes. This is the one that no matter what, if they're not reporting accurate information, you've got the upper hand. And 100 times out of 100 times, they're not reporting accurate information. So this is why I share this with you. And I'm telling you guys, you're the ones in power. You just have to continue to build your knowledge, right? Learn the material, because no matter what anybody says, you know the fact. This isn't hearsay. This is information you can literally take to court today and beat them with. Right? And get this information from TikTok, or some dude on TikTok telling me, you know, what worked. No, like we're breaking things down, guys. We're going on to reports. We're going back to the basics. And when you simplify it all, you'll realize that we're the ones in control. We're the enforcers here. To your credit report, if you don't take control over it, and that's